for psychiatric issues, learning disabilities. He's been on medication. This is not a person that I feel comfortable standing next to in this courtroom at this desk. It shouldn't be. And I think that there is a way that the state and or the court can do something that I think is just, which is figuring out a way to resolve this case in the juvenile system. I don't think Your Honor needs to take my word for it, but we've gotten a report by, frankly, in my opinion, I think he's on contract with this court to perform these kinds of evaluations. And just requiring this case to be sort of all of us to blind ourselves to the reality that this is not just a miniature adult who's sitting next to me, I think is very wrong. There's a dearth of case law on this. The leading case that I think I cited for Your Honor was from 2001. That's the last case addressing the intersectionality between, a 501A and a transfer. It's 25 years ago, almost, quarter century. In that time, we have Miller and JDB and all the other cases that talk about how different people like this young man is from other people who this court regularly sees. And so, as I sat with him, with his family, with the facts of this case, and then I understood what his background was, I felt compelled to file the motion. And I'm not blinking when I file it. I understand what the statutes say, but if the answer is that we just have to pack up our tents and leave here, there's nothing that can be done, I can't really stomach that. And my hope is that there's something that we can do in light of the fact that, the state doesn't dispute he meets every single one of these factors. I'm frankly, it's none of my business. I don't even think the victim opposes transfer. And with his youthful age and the fact that we could keep him in the juvenile court till he's 19, I frankly think that we're sitting here talking about, are we really going to keep him here when I think we all know society would be better benefited were he to be transferred in terms of the services, the rehabilitation services that are available there and not here. And Your Honor is familiar with that. That's why I filed the motion. That's my preamble. I'm happy to address it on the merits, but I'm not going to try to shine the court on that 501A doesn't say what 501A says. But that cannot be the end all. There has to be a way that this can be addressed. And all I'm asking Your Honor to do, frankly, is give me the opportunity to have a forum in which I can prove it up. Not that Your Honor even agrees to transfer, per se, but let me prove by clear and convincing evidence why it should be. And I can make that showing. I think I should be given a chance to do it.
Great. Thank you, Mr. Schrader.
Your Honor, just one point of clarification, and then the rest will just be kind of confirmation. But he is charged with dangerous nature offenses, and that has been alleged in this case, and those were properly filed at the same time as the indictment. Counts 2 and 3 are dangerous nature. It's aggravated assault, deadly weapon, and robbery. He satisfies 501A not just for the enumerated violation of the armed robbery, which is clearly delineated in that section, but also in the other violent felony offense category. And as an example of violent felony offense, and I believe Your Honor mentioned this earlier, that's aggravated assault with a deadly weapon. Mr. Hamilton is an artful attorney. He's making an artful argument based on passion, based on emotion, but not based on legal authority. The legislature has made this crystal clear. When a young individual, young but at least 15 years of age, acts like an adult in the manner in which they commit crimes, they shall be charged as an adult in the same exact manner. And that's what he did. He committed an armed robbery, carjacking, discharge of a firearm that resulted in the victim being shot, or whether it was from a direct shot or skipped off the ground, immaterial. Shot because they discharged a firearm. Those are adult actions that require, by law, adult prosecution. And therefore, the defense motion should be denied. It is moot and is not in line with statutory authority.
All right. Mr. Hamilton, anything on rebuttal?
No, Your Honor. The only other thing I would ask is if I can, the state's been given a copy of this. May I just add this to the record? These are his.
Yeah, you want to...
Can I mark this?
Yeah, just mark it as an exhibit.
Was it mental health record, Judge?
Yes, sir.
Yeah.
They need to be filed under seal?
Yes, Your Honor, just with the other claims.
Okay.
They're just his
All right.
Copy's been provided.
Let's file that as a defense exhibit A for purposes of this hearing only, and that will be filed under seal. All right. So the question is today is whether the defendant who was age 15, whether his case should be transferred down to juvenile court from adult court. It's governed under, excuse me, 13-501, and that is a statute that requires mandatory filing in adult court for anyone who's age 15 or older, who's a minor. And as I said, the defendant is 15. So he falls within the age limits of that statute. And that lists certain charges which are required to be filed in adult court. The statute uses the word shall, which is mandatory, means the same thing as must. Count 2 of the indictment charges armed robbery under 13-1904, and that is one of the statutes that's listed as one that requires adult filing. That's under 501A4. And then count 3 alleges aggravated assault with a deadly weapon or dangerous instrument. And 501 other violent felony, let's see, it's 501H4 defines aggravated assault under 13-1204 subsection A, paragraph 2, and that's what the defendant is cited with as also one that is a mandatory, it must be filed in adult court without discretion. And then if any other offenses are joined to an offense listed in this subsection, that is counts 1, 4, 5, 6, and 7, meet that definition. So the entire indictment falls within the mandatory requirement that it be filed in adult court. And while I'm sympathetic with the harshness of this rule that Mr. Hamilton lays out, our Arizona legislature has determined as a matter of public policy in the state that 15, 16, and 17-year-olds charged with those crimes can only be charged as adult. The court simply lacks any authority or jurisdiction to address the motion to send it to juvenile court. And I also would note that section 8-302, which is in the that's the minors or juvenile section of the Arizona Revised Statutes, provides that anything in 13-501 cannot be transferred to juvenile court. So for those reasons, I'm going to deny your motion. All right, and then let me look up see where we are in your case here.
We just had the